I was tagged in a Twitter thread this morning where a £3.50 car park fee turned into almost £300 worth of costs, plus a CCJ, that's a county court judgment, because the company, presumably for a parking charge notice, went to court and won, and therefore obtained a county court judgment against that person, which is going to destroy their credit rating for at least 6 years, if not longer. Now, one of the complaints in the Twitter thread was that they didn't receive the initial court papers. The first question I have is, how did they receive the CCJ if they didn't receive the initial court papers? Because ordinarily they would be sent to the same address. But that depends on who served the claim. Because when you get a claim issued, which is different to serving the claim, the issue is simply a claim number, and you can either, as a claimant, you can either serve the claim form yourself, or the court can serve it for you. Serve it simply means sending it, usually by post, to the person who is named as defendant. Now, if the address was wrong in the first instance, then those papers may have gone somewhere else. Or if the company had opted to serve the claim form themselves and didn't do so, but yet went on to court and obtained a CCJ, then if they've not correctly served this claim, then the defendant and now judgment debtor could, in theory, apply to set aside the judgment on the basis that the claimant did not complete the steps required to serve the claim form in the first instance. Now, just to explain a little bit about how this has come about in the first place, I infer from the Twitter thread that if they didn't receive the initial court papers, then they didn't file an acknowledgement of service, and they didn't file a defence, or both in this case, if they didn't receive those papers. And so that is how the company would have obtained a default judgment in default of responding to the claim form. Now, there are some circumstances where the court must set aside that judgment, meaning the judgment no longer has effect and the full claim will be heard. If, for example, the defendant has filed the acknowledgement of service and or filed the defence, but also there are other situations where the court may set aside the judgment. And those would include, as in Part 13 of the Civil Procedure Rules, in any other case, other than those I've described about responding to the claim in the first place, in any other case, the court may set aside or vary a judgment entered under Part 12, that's for default judgment, if the defendant has a real prospect of successfully defending the claim, or it appears to the court that there is some other good reason why the judgment should be set aside or varied, or the defendant should be allowed to defend the claim. Now, in many of these cases, just like this one on the Twitter thread, I have represented defendants who received judgment in default, having told me that they've never heard of the claim before, they've just received these papers. Now, it is entirely possible that there's a fairly unscrupulous practice in a number of different ways, which I'll explain now. First of all, it's possible that the claimant opted to serve the claim form themselves, but didn't, which obviously they should do. But secondly, sometimes they deliberately use a slightly incorrect address, meaning that the claim form never actually reaches the defendant in the case. So as with all of these cases, there are sometimes options to apply to set aside the judgment. You must do so promptly, and you must show reasons why the judgment should be set aside, why you should be allowed to defend the claim, or why you would have a real prospect of successfully defending the claim. So if you put all of those together in an application to set aside the judgment, then you can go back to court and have your day in court. I will link the Civil Procedure Rules in the description below. You can go and read those, or as always, you should take formal legal advice if you are unsure before taking any steps of your own. I hope that's useful. Thank you for watching.